All rise.
Be seated. All right, before we begin, I want to make sure we don't have any issues with the camera view of any victim. I don't know who's going to be here today. Don't have any children in the audience, so that's good. All right. The court will call 24 CF 232, State of Wisconsin versus Madison Bergmann. Let's get appearances.
Alicia Otten appears on behalf of the state.
Good afternoon, Your Honor. Joe Tamburino appears on behalf of Ms. Bergmann, who's present.
All right, we're here today for a sentencing hearing. We've received the pre-sentence investigation from the Department of Corrections, and we've received an updated version. I just want to verify that both parties have had a chance to review the PSI. The state?
I have reviewed the PSI and I have no corrections, Your Honor.
Mr. Tamburino?
Same, Your Honor.
All right. So with that said, we can proceed to sentencing, and I'll hear from the state first. If there are any additional participants besides the attorney's presentations and anything from the defendant, do we plan that here, just in terms of...
I do have one in-person victim impact statement, Your Honor.
Okay, good. Mr. Tamburino?
No, only myself and Ms. Bergmann. And I would just ask if the victim impact statement, if the person is going to read it or if Ms. Otten's going to read it, if it can be part of her allocution.
That's fine, Your Honor. I can include it as part of my argument.
Thank you.
Certainly. Certainly. And we'll want to perhaps have the person come up here so we can make sure we can get a good record of that with the microphones, because we are a digital audio recording system here. All right, so go ahead, Ms. Otten.
Madam Clerk, could I have the screen, please? Your Honor, there's two words I would use to describe this case today: deliberate and damaging. Deliberate choices, deliberate texts, deliberate actions that were damaging to the victim's family, the school, and this community. As Your Honor knows, there's several factors to consider here today. Per State v. Gallion, that is gravity of the offense, rehabilitation of the victim, and the need to protect the public. First, gravity of the offense. These offenses are serious per the legislature. Ms. Bergmann is being sentenced on 3 felonies here today. The first, child enticement, which is a Class D felony. There was a lifetime supervision enhancer on that. The other 2 are sexual misconduct by a school staff member. Those are both Class I felonies. And then to consider today as well are the dismissed but read-in sentences of first-degree child sex assault, use of a computer to facilitate a child sex crime, another child enticement, 3 more counts of sexual misconduct by school staff, and expose child to harmful descriptions. The legislature generally takes crimes against children very seriously, as shown by the level of offenses here, as well as some of them having a mandatory minimum. None of the ones being sentenced on today do, but some of the dismissed but read-in ones did have a mandatory minimum of 5 years. The offense itself can be shown through the text messages between Ms. Bergmann and the victim. They create a timeline of the events. The first text message was sent on December 26, 2023. They're talking about meeting on the slopes for a snowboarding trip they went on together. Ms. Bergmann was helping supervise some of the children there, and the numbers were exchanged. Things start escalating in February of 2024. February 3rd through 5th, Ms. Bergmann and the victim start talking about her sexual dreams. She starts with, "I had a dream about you, stuff that I'll tell you about Monday." She doesn't want to describe it in the text. They go on to talk about this more, and on February 5th, the victim again says, "Bro, your dream was crazy." She says, "I wasn't even going to tell you." Victim says, "Mine are the same, but no touching. Just like the first part before a long time." Ms. Bergmann says, "Delete, delete." February 5th, there's an acknowledgement that Ms. Bergmann had offered to stop the text for about 80 days. Victim mentions, "We really failed at that." She says, "We failed a lot, and that's on me, honestly." February 7th, the first indication that she wants to hang out with the victim alone together after school. She says, "I could drive you home." February 16th is their first phone call. February 20th through 21st, victim says, "I'm wearing a short sleeve just for you." And the next day, "Yeah, and just running your hand on like my back and arm." Just this first indication of physical touch at school between the victim and Ms. Bergmann. February 23rd, the first plans to kiss. Ms. Bergmann, "I have to tell you later that I was so close to doing it as you were leaving, but I made the better, smarter choice, unfortunately." She says, "It would have been so dangerous." She says, "There's no cameras in the classroom. I have to be the adult and make good decisions." February 24th and March 4th indicate increased touching between Ms. Bergmann and the victim here. They talk about playing with each other's hair. She says, "When I put my hand in your hair and pulled you back and you said, 'Are you trying to kill me?' I was gonna. I'll just dream about it all weekend now." She says, "I'm not trying to go to jail for real." March 4th, it's the other way around. She says, "Oh my gosh, when you were playing with my hair today." Victim says, "I was trying to make you meld." She says, "Oh my gosh, I got so red." March 9th, 2024 is the indicator of the first kiss, a kiss on the cheeks. In this case, she says, "We kissed cheeks today, haha." On to March 27th, they are now FaceTiming each other. On to March 28th, they talk about having sexual contact with one another, wherein the victim is touching Ms. Bergmann's vagina. This is pretend, but very detailed. Victim says, "Bro, your thing is hairy and like rough, haha." Ms. Bergmann says, "Bro, so is guys." She says, "Where you actually lick is no hair, just above and around it." Victim says, "So what do you like?" There's 2 deleted messages there from Ms. Bergmann. Victim says, "Like hands inside, so just put a couple fingers in." April 8th is the first indication of the chest touching that we've discussed several times in this case. She says, "Okay, this morning when I grabbed your shirt and like pulled you into me, oh my goodness, I don't know what it was, but that moment just got me even more obsessed." Victim says, "Haha, yeah, I realized that you were touching my chest a lot." Again, also indicates that increased touching. April 10th, they share messages about the first kiss, this time not cheeks, but on the mouth. Victim says, "No way in hell that just happened. Girl, oh my, how did that happen?" Ms. Bergmann says, "Oh my lord, dude, that was actually so good. I'm shaking. Honestly, so glad I just went for it." Victim says, "I don't know how I left you after that." Ms. Bergmann says, "Oh my gosh, I can't believe that just happened." Victim says, "What do you mean? That was my first. I want to do it 1,000,000 times more." Ms. Bergmann says, "Haha, me too, it's so bad. You falling on the floor after, you're too cute." April 15th, we get increased details behind the kissing as the kissing continues. Victim says, "Bro, that was so long and so good, and your hug was so good and tight." Ms. Bergmann says, "I waited all weekend to do that. I'm so in love with you." It was like almost 2, kind of went in and out and back in. Victim says, "Haha, yeah, 'cause like your lips gas up and it's close." Ms. Bergmann says, "I could be totally wrong and you can't be embarrassed at all." Victim says, "How did you think I was hard? Did you feel it?" She says, "Haha, yes, when I hugged you." April 19th indicates how regular the kissing was and how they progressed to more than just kissing. Victim says, "Right now we have already kissed 9 or 10 times in only a week and 2 days. Ms. Bergmann says, "Oh my goodness, that's actually crazy." She says, "You kiss me better than Sam does. Like you saying we always make out, I try to be, but he always just kisses me with his mouth closed and super fast." Same day on April 19th, victim says, "Because you did something different like that, that was not just a kiss." Ms. Bergmann says, "Haha, when I hugged you before you left today, I felt you again." April 22nd, the physicalness is escalating. There is now touching of the victim's leg. Victim says, "Your dress today, oh my sexy, and when you touched my leg, you went like so far up my thigh, and then when my leg was in between yours at the back table, my leg was inside your dress and your legs were just squeezing mine." April 27th is more of the chest touching. Ms. Bergmann says, "I love having my hand on your chest too, like I always did, but today I could really feel your heart beating so much." April 27th is that last text I have on the slides here. May 1st is when Ms. Bergmann got arrested. I think it's important to note how this is escalating behavior, grooming behavior. This was not the end for Ms. Bergmann. They made plans for the future, for the summer in their texts. I don't think we will ever truly understand how far the touching went, but we know it continued to escalate, and it was deliberate. The grooming would have continued, the touching would have continued. If not for the parents catching on to these texts and calls, checking the victim's phone, and touching or getting in touch with the school and law enforcement quickly. Ms. Bergmann has no credit for it stopping. It was all the family of the victim. Also, as to the gravity offense, Ms. Bergmann was in a position of power, a position where she was supposed to teach children not only the class materials, but how to interact socially. She failed at that. She crossed all professional and ethical boundaries there. And last, an aggravating factor was the age gap. Ms. Bergmann was 24. The victim was 11. The victim was a child, not someone you fantasize about sexually, not someone you text sexually, not someone you make the deliberate choice to have a sexual relationship with at school. We cannot rehabilitate someone that does not take accountability. Throughout the paperwork we've all received, Ms. Bergmann says she takes responsibility and accountability, but she also says she dissociated when she texted the victim. They were only words. They were pretend. They were a fantasy. We knew it would end on May 31st, 2024, the end of the school year. She was never alone in a classroom with the victim. They only kissed one another on the cheek. This is not accountability. This is excuses, this is theories, this is lies. Going back to the text messages. She says she disassociated when she texted the victim. There were 35,429 messages from December 26, 2023 to May 1st, 2024. Your Honor, that's 130 days. If you do the math, that's 275 texts per day. They were only words. It was pretend. It was fantasy. The words were specific. We saw the aggravated text in that timeline just now. They were very specific about intentions. They were discussing the day, what happened that day, analyzing what happened at school that day. And the victim was 11. He was a child. He would not understand a complicated fantasy or pretend. He was just interpreting the actions as they were happening. Knowing it would end at the end of the school year. The top of the text messages here, victim says, "Have you started to plan your wedding yet?" She says, "Gotta wait till I'm 30 now," when the victim would be 18. Those are plans for the future. Other text, she says, "I'm gonna get in trouble at school because you know where I live. Well, now you know where I'll be all summer." Continued plans, continued future post that May 31st date. She says she was never alone in a classroom with the victim. Law enforcement received camera footage of the school. It was clear that Ms. Bergmann and the victim were alone in her classroom several times. There's text messages that she knows there's no camera specifically in the classroom. There's text messages about, "I wish we didn't have bus duty, could have stayed in class." These again are plans. She's bummed about the timing of the bus schedule. She's bummed about other students being in the room sometimes. This is all in the text messages. Only kiss one another on the cheek. That is clearly not true. I just went through that timeline. It escalated. There's specific actions being described by both Ms. Bergmann and the victim. Again, say you're holding yourself responsible, accountable, is different than interpreting that, internalizing that. Ms. Bergmann has failed to do that. In her psychosexual evaluations, she describes it as innocent friendliness towards the victim, never thought about actually having sex with him, and that she does not blame the victim. She's putting herself in the victim position. That is not the case. She was the adult. She was the example. No one blames the victim here. Protection of the public. Confinement here is absolutely necessary to protect the public. She was in a public setting when she was a school teacher. She was in that public position, and she behaved inappropriately with an 11-year-old. She not only needs treatment, but there is a need for punishment here for those who cross societal lines so grievously as Ms. Bergmann did. This case has been in the public eye, both locally and nationwide. It's so public because we don't usually see this big of an age gap between student-teacher relationships. They're always inappropriate. But again, we're talking about a child here, an 11-year-old. There's no comparison to be made to other cases because it's so unique. We also have the impact of the crime on the victim and the victim's family. Gallion makes it really clear that impact on the victim is also an important factor. The victim himself submitted an impact statement to Your Honor in which she explains how Ms. Bergmann broke his childhood, that he no longer feels safe at school, where he's now bullied and questioned by his classmates, where he now has to take extra precautions because of what happened. He says, instead of a normal life where my biggest worries were homework and sports, my life became serious talks and appointments. He needed therapy. He needed to be able to cope with all of what happened, and his childhood will forever be changed, Your Honor. He says she knew exactly what she had done and chose to keep doing it. 35,000 text messages. We also had a victim impact statement from Mom. But never did I imagine having to navigate my child being sexually abused by someone he trusted, his teacher. That reality has brought a level of stress, tension, and chaos into our home that few can understand. Huge impact on the family. I also have Dad in the courtroom today. He would like to read a victim impact statement. I'm going to pause briefly for him to do that.
All right, come on up. You can just have a seat and then bring that microphone close so we can hear you and state your name for the record and proceed. Thank you.
All right, thank you. Sorry. I'm Tico, and I'm going to read this. My son actually asked that I read this, so I apologize. Just have to get this in the right spot. So my name's Tico, and I'm the father of the victim, and trying to capture the breadth and depth of the damage caused by Madison is impossible. There's no way in a few minutes to really fully convey how far her actions have reached into my son's life and into our family's life, but I will do the best to give a clear window into what we now live with every day. So, since this happened, my son was just kind of a normal kid, doing normal kid things, playing sports, but now he has to live with the consequences of her decisions. He faces things where he gets bullied at school on a regular basis, and then, over a year later, they whisper as he walks through the hallway, says, "Is that the kid? Oh, is that the kid that got his teacher in trouble?" These are the types of things that this 11-year-old has had to deal with. And then he had anxiety, and he's had to go to counseling for that. So anxiety, nightmares, constant stress, constantly wondering, where did his simple childhood go? And I think you've seen what he's put in his letter, so I'm not going to reiterate what he said. But then the other, even little things he's lost, right? So his phone, because the phone was weaponized against him. So other kids are looking at things and sharing things, and he can't participate and has to explain why he doesn't have a phone and have access to one right now. And this kid's an athlete as well, right? So he missed his last grade school track meet. And for some people might say, oh, well, he missed the grade school track meet. But, sports is this kid's life. He is that kid where when you say sports is life, that's this kid. He usually wins all the events. He looked forward to it. We all looked forward to it. But we had to say it was not safe for him to be there, emotionally and otherwise, because of everything that was going on, because we are in a small community. And these things impact him. And they keep following him. So through middle school, it's been a lot of the same. Passing between classes, he's got to find different ways to walk so he doesn't have to avoid people. There has to be accommodations in place for him so he can exit when something's triggering. And even most recently, and the thing I wanted to underscore too is like, this isn't a past tense thing. This is the last 7 days. I'm not going to go into this ad nauseum, but just I want to kind of convey the everyday impact. So we go to basketball practice, it's scheduled. All of a sudden we look at the schedule. It's a schedule at Rivercrest Elementary where he went. The last time both he and I were there was the day Ms. Bergmann got taken out of the school, right, and pulled out of there. So very triggering, but then as a dad, I have to ask him, again, are you okay having practice there? I've got to trust his judgment. I have to then think about, do I ask the coaches and give them a heads up? Because this isn't something that we necessarily want broadcast in our small community, right? And then the next day, he's kind of off. And then I'm like, is it because he's just a kid? Or is it because something was triggering for him? I mean, so there's this whole cascade of things that you would think like, oh, we're going to basketball practice. And it gets exacerbated by this. And this was last week. This wasn't, right after. These things still come up. The other things that happen as well is driving home with my daughters, because this impacts the family. We take a call. Don't know who it is. It goes on speakerphone in my truck. It turns out it's the school. There's an incident at the school. It turns out in a reading class, there was a topic about a teacher that coerced a student, and now it was going through the legal system. The teacher overreacted, and it became this huge scene. And all of a sudden, he got pulled out of the classroom right away. Then I get a call, and then my daughter, because we didn't know who it was from, and the teacher just went in and blurted all these things out. I'm not faulting them, but in this impact statement of my family, like these things pop up. Clearly, that changes the dynamic of that whole family interaction, and all of a sudden, all my priority and all my time that's allocated to my 6 kids gets reallocated to try and resolve this. And then at that same night, then I get a call from the principal. So this creates a dynamic not only in the family, but in the community, because now everybody's looked at differently, viewed differently. And these are just basic, everyday things that shouldn't be happening with an athlete that's a straight A student, with kids that are kind of upstanding kids in the community. And then even the other things, again, within this last week, physical therapy. You go to a physical therapy session, no big deal. But now it's a female physical therapist. And because my son only confides in me, I'm super sensitive about these things, and we have an agreement in how we interact. So then this, what's supposed to just be a physical therapy appointment, now becomes a whole thing. Because I'm like, are you okay with it? Are you sure? Right? And so these things that might seem trivial, might seem like, oh, water under the bridge, it happened a while ago. I mean, this is just, the last 7 days is what our reality is like all the time, and it affects the family and it affects how things go. The last 2 things, and then I'll try and be brief as I can, is just around, so there's that, right? So just this impacts the whole family. And then, I reread the text, right? Because I have access to all these things too, because they're on my son's phone. And the thing that to me is like, about all this and why I wanted to say something, and why my son wanted me to say something, in his own words, he's like, I have to live with this forever. He's like, whatever punishment she receives should be forever. Right? I mean, he doesn't necessarily know what that means, right? The whole context of it. But again, when I reviewed the text too, it's very deliberate. Talking about touching his leg, talking to my 11-year-old son about her period, talking about his erections. I mean, like very, very, to me, it's like very, very disturbing stuff. It wasn't like a oops, like a fleeting thing. It was over a window of time and only got intercepted by parents to kind of cut it off. And so that's the other part in looking at like, what do we want out of these things? And so what I was asking for, humbly and respectfully, is that we impose the strongest sentence that you believe is appropriate, including the maximum amount of time of confinement that's possible. And only you can determine what that is. But I think the sentence has to reflect the seriousness of the harm. We have to protect other children in this community, and then recognize what's also been taken from my son, because this will follow him and the family for the rest of our lives. So I appreciate that, and thank you for listening.
Thank you. Ms. Otten, you want to continue?
Yes, Your Honor, thank you. Last, Your Honor, I believe probation would unduly depreciate the seriousness of the offense here. I think probation would be a slap in the face to the victim's family, and the community, who should be able to entrust the school system and their child's teachers from taking care of their child's welfare, and that's not what happened here. Again, the actions here were deliberate. There was clear consciousness of guilt. There was a note on Ms. Bergmann's desk that was later found apologizing to the victim. She regularly tells the victim, we should stop texting, delete these texts. Consciousness of guilt, deliberate actions. Damage. You heard from both parents. You heard from the victim. This has caused extreme damage. This has caused extreme damage in their home, in our community. And again, we need to show the community that we care, that we want to protect our children, that we send to school every day, which again should be a safe place. For all those reasons, Your Honor, the state is asking for 12 years of initial confinement, 14 years of extended supervision. If run consecutive, all counts have a total of 18 years of initial confinement and 14 years extended supervision available. I believe that maximum extended supervision is available. I believe 12 years is a fair compromise here. That's taking into account that Ms. Bergmann doesn't have a history and that she has been in treatment. But again, I do believe punishment is necessary here. I believe 12 years is appropriate. This recommendation is based on the facts here. I know Ms. Bergmann made a note in the PS.
Let me stop you there for a minute. So, 12 years of initial confinement on count 3. 14 years of extended supervision. Are you proposing some consecutivity here? Because
Correct.
you're going to have to be more specific.
Understood.
So take them one at a time.
On the child enticement count, Your Honor, I'm asking for 9 years initial confinement, 10 years extended supervision. On each of the sexual misconduct by school staff, I'm asking for 1.5 years initial confinement, 2 years extended supervision, all to be run consecutively to each other.
Thus 12 years and 14 years total.
Correct.
Do you have recommendations regarding conditions for extended supervision?
Your Honor, I believe the conditions that were addressed in the PSI are all appropriate. I concur with those.
All right, and I'm sorry to interrupt you. Do you have more?
I don't, Your Honor. Thank you.
Very well. Mr. Tamburino.
Thank you. Your Honor, as the state has correctly pointed out, what are the purposes of sentencing? And it is correct. Obviously, there is the punitive part, which is based on the gravity and seriousness of the offense. And then there's also the rehabilitation of the defendant, as well as the protection of public. And Gallion also, in the case law, does support that there should be some type of consistency in sentencing. Now, I'd like to address first the issue of the rehabilitation of the defendant along with public safety. A rehabilitation of someone in the criminal justice system is extremely important. Why? Because unless everyone in the criminal justice system is put away for their life, they will be out at some time. And we know that the best way to protect the public is to have someone who is under supervision, who is particularly amenable to probation, who has been through treatment, who the prognosis is that further treatment would be quite successful, who has shown that they can obey the rules of conditional release, of under court supervision. All of this would tend to show that a person is particularly amenable to probation and that a prison sentence would not be warranted. And those two things do go hand in hand. And in this case, Your Honor, we could look at a number of materials which would support a probationary sentence. And this probationary sentence does not disrespect, does not put any type of light on what the victim has suffered here. It does not diminish what happened in the case. Rather, this person, Ms. Bergmann, will have the rest of her life as a sexual offender registration, will have, could be dozens of years under court supervision, will have to do, even under a probationary sentence, some type of jail time, will have strenuous conditions placed upon her. Now, let's look at the materials that we have. We do have the pre-sentence investigation, which is very complete, and Ms. Voles, in that case, did what's called a COMPAS evaluation, a correctional offender management profile, alternative sanctions assessment. And through that COMPAS evaluation, the Department of Corrections, there was a low-risk assessment, meaning that almost all the factors, except for that one factor, which is the case at hand, the seriousness of the case charge, shows that Ms. Bergmann has a very low risk of any type of recidivism. Second, what's called the criminogenic opinion, basically all of the information that the pre-sentence investigator took into account about Ms. Bergmann's history, her statements, all surrounding circumstances. And what did that show? Again, a very low risk for recidivism. And then what the Ms. Voles writes is that in sex offender cases, other analytical tools would be necessary to see or to make an opinion as to whether or not this person would likely reoffend. Now, the state never requested, and if they did, we would have agreed to it, a psychosexual evaluation done by whoever the state would pick. But that other analytical tool we did provide, because as soon as Ms. Bergmann became involved in the system and was abiding by all of her conditions of release until she was remanded into custody about 3 months ago, she went into a specific type of therapy and treatment for sexual offenses by a woman. She went through a psychological evaluation which took quite some time, and those other analytical tools show a very low risk of recidivism. First, let's look at Dr. Marston, who provided the psychosexual evaluation. He gave Ms. Bergmann a battery of tests, not only for intellect, but also things like objective and projective personality tests, inventory assessment of psychosexual functioning. And based on all of that, all of her scores showed a prognosis of success in treatment and an unlikelihood that she would reoffend. He also administered diagnostic, developmental, and psychosexual interviews. And again, what were his conclusions? Specifically, that she has a very low risk for recidivism. She's an appropriate candidate for community supervision, highly motivated to succeed in treatment and probation, and that prison would harm her recovery. So those other tools that the PSI speaks of, other tools that could help the court make an assessment as to whether this person, Ms. Bergmann, would have a likelihood of reoffending, those other tools show that in fact it would be unlikely for her to reoffend. And then look at the PSI's alternative recommendation if probation is imposed. And that recommendation really is buttressed by our private pre-sentence investigation, which we also submitted by Ms. Butler. And what do we see? Well, the bottom line to all of that, Your Honor, is that in this type of a case, when a person would be placed on, again, a very strenuous probation with specific conditions that would have to be met, as the saying goes, the prison door is always open. If she, in fact, violated any condition, even if it's something like not maintaining contact with the Department of Corrections, anything like that, the court would well within its right to send her to prison. The recommendations for her being on probation would be serious. And if you look at her history and what she's done, you could see how she would succeed in accomplishing those recommendations. Why? Well, first, Your Honor, as the court knows, there is nothing in her background, other than this case, which is a serious case, that would ever indicate that there would be some type of serious matters in the future. This is a person, and I know obviously counsel in the court is experienced in sex offender cases, of course, but we see in so many situations that there is a history with many people who commit sexual offenses. Some type of history to show that they might not have had a conviction in the past, but they sure have had some type of behavior which would indicate that there could have been sexual misconduct in the past. Might not have reached the level as in criminal court, proof beyond a reasonable doubt, but some type of indication that even by a preponderance of evidence, there might have been some misconduct in the past. That doesn't exist with Ms. Bergmann. There's been an extensive background check on her. She doesn't have that. And this case has been litigated for almost 2 years now, and nothing has come up that would show otherwise. When she became part of the system and the court placed her on very specific conditions of release, she abided by all of them. And in fact, she did so well that this court released her GPS monitoring, which was appropriate because she was doing everything she was told to do. And even since being in jail the past 3 months, she has availed herself of every program that could she conceivably become involved with in the jail. She has gone to all different types of jail programs, support groups, Bible studies. She's never been an idle person, and she has not been in the jail either. She works in the kitchen. She immediately got a job working in the kitchen. She tried to make the most of herself doing this. And she's done that because, again, when she is specifically on any type of conditions, she will abide by them. The other thing that would help her and help the system and society by placing her on probation, she will be a success because she has a very great support system. She is in a unique position compared to so many criminal defendants in the system. But we have seen a revolving door sometimes with certain criminal defendants because after they leave this courtroom, they go into a situation where on a number of occasions they fall back into criminal behavior. Now that could be because of a psychological profile, of course, but concomitant with that is that they go back to the same type of environment where it makes it more conducive that they would get into future bad behavior. That's not the situation with Ms. Bergmann. She has been blessed, very fortunate, with a family who stands behind her. They know that she has committed a grievous act. There is no doubt about that. But they still love her and support her. If she's placed on probation, she, as she has before, has a family job. She will not be dependent on social services, any type of welfare, a burden to the system. She will have a full retinue of all of her family members to make sure, as during the time on conditional release, that she will abide by all conditions placed on probation. And she will have the opportunity to continue with her sex offender treatment programs. I mean, just in the short time that this case, well, not short time really, over a year, was litigated, she went through over 37 sessions in her treatment program. And that's on top of the work that she was doing, on top of the psychological evaluation or the psychosexual evaluation that she was working on. This type of person, the only way I could describe it is basically what the victim's mother said in the PSI, where she specifically said, and of course it's the victim's mother, and she takes this case very seriously, I'm sure. She says hurt people sometimes hurt people, and that this act shouldn't define Ms. Bergmann. She truly hopes that Ms. Bergmann gets help. Jail time doesn't matter. Ms. Bergmann's life is already in pieces, and she hopes that she will be helped in the future. And this is the victim's mother who cooperated with probation, someone who the probation officer actually spoke to. I was quite surprised when we got the letter from the victim a few days ago in the wording, the very adult phrases that were used, because it was something that we didn't hear from the victim's mother, nor did we hear any of that throughout, again, almost 2 years of litigation. But Ms. Bergmann does admit to the seriousness of this offense. She always has. Then turning to the gravity of this offense, Your Honor, with child enticement, along with the consistency in sentencing. Now, of course, every individual has to be sentenced individually, but it is totally permissible for the court to look at other cases involving child enticement, specifically local cases in St. Croix County or in the Judicial District. And I'm not going to go through every case that I've submitted to the court, but you can see that what we submitted was the cases that we could find, and really none older than 2008. Some of these are very recent. And in the probation cases, what do we see? Even back in that 2008 case, child enticement, that person had a prior sex offense, was given probation. 2018, there were 2 cases. One involved the victim of a 14-year-old girl with an attempted meeting to have sex. Much more than an attempted meeting. There was never an attempted meeting here. Probation. The other one from 2018. The attempted sexual assault of a 15-year-old boy. Plans to have sex. The defendant even traveled to meet with the victim. Probation. 2019, an attempted sexual assault of a 15-year-old boy. Planned to have sex. Arrested on his way to meet the victim. Probation. And 2020, again, attempted sexual assault. 52-year-old male, 13-year-old victim girl. Sexual pictures. That's nowhere part of our case. Evidence of repeated behavior with other juveniles, probation. In this case, Your Honor, yes, the texts, many of them obviously horrible. There's no doubt about that. But as we know through how many motions we've had in this case, all of the discovery, the victim's statements, the victim's 2 video recorded statements, there hasn't been any touching beyond the kissing that the victim even stated on his cheeks, and that Ms. Bergmann touched his chest. And we've all known that. How many times have we been in court, and how many times have we on the defense side made motions concerning whether or not the chest touching would qualify as a breast touching? But regardless of all that, Your Honor, if any other touching would have happened, we would have known that. The victim, even since the time of the beginning of this case, after his statements, after the video interviews, never was there an allegation that any other part of his body was touched. And if you juxtapose that with the prison cases that I have submitted to the court, all of the prison cases involving the sexual abuse all involved touching of the genitals, all involved over an extended period of time. Except that one case, but that one case was actual intercourse, which is not even close to what happened here. I would specifically highlight that one case from last year, the Rosales case. Now that's not a child enticement, but that is a school staff member obviously charged. But in that case, that was a school resource officer, which you really, that is the ultimate position of trust. You're a peace officer, you're working in a school, you have law enforcement background and authority, and in that case, it was a learning disabled victim. He solicited sexual images, planned on having sex, and it was an 18-month prison sentence. And then, of course, the case that I pointed to in 2017, the Hall case. In that case, the defendant went through a trial. He was found guilty by a jury. He still didn't admit his guilt. And he had a prior sexual conviction, and the court sentenced him to 12 years. So, Your Honor, in terms of punishment, that factor, punishment is severe in this case with a lifelong sex offender registration, as well as I've stated, dozens of years on some type of supervision. And again, the prison door is always open if there's any violation of any of those conditions. And is Ms. Bergmann's life shattered? Yes, as is obviously the victim. They will both have to find their ways. But Ms. Bergmann, as a lifelong sex offender registration, even to the time when she is my age, 61 years old, if she wants to, at that point in time, go to Illinois to visit a family member or go to a funeral, you literally have to make sure that the state you're going into, you comply with their sexual offender laws. Why? Because if you stay in a state for too long, even in some states, say 30 days, you would have to register in that state, and you could be in violation. So it's not something that should be dismissed as, well, they just have to register. That's not the case. Also, it affects for your lifetime where you could live. You can't just simply grab an apartment somewhere. There are background checks, record checks, and many places, most places, do not want to have a sexual offender in their community. So it is a lifelong branding. It's not something that should be considered lightly. Probation in this case, with all of the recommendations and continued treatment, would actually be in line with the gravity of this offense. Because, yes, the texts were completely horrible, and Ms. Bergmann did take responsibility. She did say that much of that was fantasy, as you could even see in the text. But never at any time was there any touching other than the chest, nor was there any type of actual planning to meet, to have sexual contact, like we see in the other cases. That didn't happen here. And there was time for it. As the state has pointed out, the communication started basically in December of 2023 and lasted till basically mid-May of 2024, late April of 2024. There was plenty of time for any of that. There was time off from school. There were holidays. There was spring break. None of that happened here. So, Your Honor, we feel that the appropriate sentence would be a probationary sentence. The court could do a consecutive probation on all of the counts, and whatever the court sees fit for some type of an extended supervision. Ms. Bergmann would also like to address the court, Your Honor.
Thank you, Mr. Tamburino. Ms. Bergmann, you can tell me anything you'd like for purposes of our sentence here today.
Could she remain seated, Your Honor?
Certainly.
Thank you. Your Honor, thank you for the opportunity to speak. Thank you. I want to begin by expressing my deepest and most sincere apologies to the Huber family. I am so very sorry for the pain and stress that my actions have caused. There is no excuse for my mistaken choices and my mistaken actions. I want to make it absolutely clear that I take full accountability for every boundary that was crossed. I hope that your family has been able to begin to heal and find some peace in your lives again. I know the journey will be long for your family as well as mine. Your Honor, I do believe in the justice system and people being held accountable for their mistakes. I believe that that looks different for every person. And in my case, there's not only the current punishment of being incarcerated, but many lifelong punishments to come. I have lost the teaching license that I studied and worked for 4 years. I will never again be able to pursue my passion of working with children in any sense. I will be on the sex offender registry for the rest of my life. This is going to greatly impact the future I had envisioned for myself, including having a family and children of my own, new and different career paths, and even buying a home or deciding where to live. I fully understand and accept this consequence, but I also ask the court to recognize how profound and life-altering it already is. It is a daily reminder of the impact my hurtful choices have had on others, and it will remain with me for the rest of my life. Additionally, because of the worldwide media coverage of my case, I will be facing ridicule from strangers and friends forever. The media coverage has not only already affected my life and feeling of security and safety, but also my entire family's. My name is in connection to our family business, which has led to online harassment of not only me, but my whole family and their means of making a living. Before being arrested in May of 2024, I was in a deeply unhealthy and emotionally abusive relationship that caused me to become isolated from friends and family. I allowed that emotional vulnerability and isolation to cloud my judgment and alter my ability to process the reality of my inappropriate and harmful decisions. However, Your Honor, since then I have begun to find healing and growth for myself through being back in the safety and support of my family, as well as participating in talk therapy and sex offender therapy. Lastly, Your Honor, I would like you to consider the time that I spent in the community on bail. Excuse me. During that time, I was compliant with every restriction placed upon me, including not having contact or communication with my 3 younger step-siblings for months until it was approved by the court, not having contact or communication with anyone under the age of 18, which includes all of my cousins. I also remained off the internet, had no phone, and had no online or phone contact with anyone other than my lawyer for 17 months. I also stayed within the radius I was given while on and off of GPS monitoring. I'm not seeking to avoid punishment. I'm already facing lifelong consequences, but I am asking for the opportunity to prove that I am willing and wanting to be a productive, law-abiding member of society. I will never be able to undo the damage I have caused, but I'm committed to doing everything I can to ensure that I never harm another person. Thank you, Judge Nordstrand.
Thank you. Is there anything further to present to the court with regard to sentencing?
Nothing else, Your Honor. Thank you.
Nothing else, thank you.
We've heard a lot here today about the factors that the court has to consider as it hands down a sentence here today. And I think it's important to take a look at those once again, to describe them in the place where we got them as judges and as lawyers. From the State v. Gallion case from 2004. This came not long after the changes that happened, significant changes in the Wisconsin system of sentencing. And I'm going to read a few paragraphs from Gallion because whenever we have a sentencing decision, I like to go back and look at what Gallion says to remind myself of the importance of these principles. Why do we do this? Why do we have these factors, and how do we consider them? And I'm going to speak in and out of Gallion here for a moment. This is starting at paragraph, or at section 39. Judges are to explain the reasons for the particular sentences they impose. How much explanation is necessary, of course, will vary from case to case, as it always does here every day. Judges, however, are required to provide, and this is a quote, a rational and explainable basis for the sentence. That's the source of this identification of factors. It's a guide from our Supreme Court and ultimately from our legislature as to what is important. Circuit courts are required to specify the objectives of the sentence on the record. These objectives include, but are not limited to, protection of the community, we've heard about that here today, punishment of the defendant, rehabilitation of the defendant, we've certainly heard about that, deterrence to others, we haven't necessarily heard about much of that in our argument here today. Courts are to identify the general objectives of greatest importance. These may vary from case to case. In some cases, punishment and protection of the community may be dominant objectives. In others, rehabilitation of the defendant and victim restitution. may be of greater import. Still others may have deterrence or restorative justice approach as a primary objective. Courts are to describe the facts relevant to these objectives. Court should explain, in the light of the facts in the case, why a particular component, part of the sentence imposed, advances those particular objectives. And I offer that because I think it's important to understand as we look at these factors, in every case we balance what's the most important factor or factors in this case. Sometimes they all apply. Sometimes others are more, one is more important than another, etc. Under our statute, and we heard specific reference to this in 973.017, the primary factors we have to consider according to the legislature is protection of the public, very similar to what they were saying in Galleon. The gravity of the offense, that's not necessarily, it's evident in Galleon, but not as specifically, and the rehabilitative needs of the defendant. So these are the things that we have to consider as we begin our process here. Now, I also like to make a record of exactly what we've looked at as we come to the sentencing decision. Certainly we've looked at all the pleadings. We've had motions, as Mr. Tamburino has mentioned, significant motions for a number of, over the course of the last year or so. We've had a plea questionnaire and a plea process, and we've looked at that. We have an amended PSI. We have a sentencing memo from the defendant. We had an alternative PSI filed, I think, back in September that the courts reviewed. A psychosexual evaluation, a letter from a therapist as well, I think, at that point. We've had, as I said, the sentencing memo and also some certificates from the jail about the work that Ms. Bergmann's been doing in the jail. And then we had a written victim statement that was recently filed. And have I forgotten anything? I think that covers the waterfront.
It does, John.
It does.
Now, so I've looked at all of that in anticipation of our hearing here today. Now, Ms. Bergmann's been convicted of 3 felony crimes involving children. Child enticement under 948.07(1). That has a maximum sentence of 25 years, 15 years of incarceration, 10 years of extended supervision. We also have 2 counts, I think 6 and 8, in the first one was count 3, 6 and 8 of sexual misconduct by a school staff person under 948.098. And as Mr. Tamburino learned in his research, it's a relatively new statute that was passed, only became effective early last year. And so there are not many cases. That is, the penalties associated with that is 3.5 years total for each, with incarceration maximum of 1.5 years and extended supervision of 2 years. Now let's talk a little bit about the gravity of these offenses. And I think, and I don't want to minimize the fact, and I accept that we have also dismissed and read in a number of other charges, some very significant charges, and I've taken those into account here today. But I want to focus on the 3 felonies for which Ms. Bergmann has been convicted. And the gravity of those offenses. The gravity really arises out of, in many ways, the victim and the circumstance of the victimization. That is, a 5th grader and his teacher. That's the source of the gravity to me. And, we've got differing charges. Obviously, child enticement, a much more serious charge in terms of, alleging sexual contact intent. And we've got this these two lesser felonies, and I say lesser in quotes because I don't mean to minimize by any means, but Class I felony and two Class I felonies and a Class D felony. But the gravity collectively of all of these charges for which you've now pled guilty are the victim and the consequence to the victim. Beyond that, and I'm going to get into this in a little bit, there is the pervasiveness of the actions. And I think this goes to, and I do have a moment when we'll talk about those other cases, Mr. Tamburino, a few of those, at least generally, in terms of your analysis of sentences for child enticement in this new school staff member charge. This is unique in many ways because of, I think, the age gap is important. I think the position of power, or I think a better word perhaps is trust, is important. And then if you look at the time frame and the pervasiveness of the activity, which I'm going to get into in a minute, the gravity becomes even more apparent in my estimation. The gravity of this offense, and I was thinking about this as I prepared today, is almost demonstrated by the party's willingness to stipulate to lifetime supervision for sex offender status. And we'll get to this at the end, but you know, that's not automatic. It's alleged, it's agreed to, but I have to find, under the statute, first of all, the proper notice was given, which it was, and that it's necessary to protect the public. That's required. And so it's counterintuitive to me, in a sense, to, on the one hand, say sex offender registration is agreed and this burden will be with Ms. Bergmann for the rest of her life, and at the same time she poses no risk to the public. So I just offer that. That's a little bit inconsistent in my thinking, but and I'll say one other thing about that. Our Supreme Court has already said that sex offender registration is not punishment. That's why we don't have to offer a warning about sex offender registration being required at the time of plea. And our court has ruled that sex offender registration and that level of supervision is not punishment of the defendant, but it's protection of the public. Okay? Now, is there a very real consequence to the defendant subject to that? Yes, granted. But I just wanted it understood that from my purposes here, our Supreme Court has explained that it's not punishment, though obviously it poses a burden to a defendant. Now, one could easily minimize the gravity of these offenses and make, I think, an effective argument to a limited degree that there was not the level of sexual contact, I think, Mr. Tamburino, that you were talking about in these other cases. And I think that's a fair argument. That, however, has to hold up against the other reality in this case, and that is what happened here. It's not the same. It's not like many of those other cases. It's a different kind of terrible, frankly. Horrible, I think that might be the word that was used. So what do we know about the facts? We have an 11-year-old boy, a 5th grader, first contact with the defendant as a 4th grader, I think. That's what was reflected. the contact, the personal contact is happening in school, and it began to increase during his 5th grade year when Ms. Bergmann became his teacher. She was even surprised that he was assigned to her class because there was some concern about them being friends before that 5th grade started. But nonetheless, he was. First message, I should say, emails that exchanged between the two were from November 29 of 23 to October 29 of 23, according to the investigating officer. There were 34 emails, and nothing untoward specifically, but nothing about learning, or I think that's the way the officer referred to it. Nothing about learning from the teacher to the student, the 11-year-old. Then, a couple of months go by and we get to December 26 of 23 for the first message. And obviously I didn't go through all the messages. There were 35,000 messages or so. I went through the ones that were provided to me and paged through the exhibit that we had from our original preliminary hearing. But they were provided to me in the PSI, largely and to some degree in the amended complaint. The last message I saw was from about April 29. Total text, 35,429. So between those dates, I did some math, Ms. Otten, and I came up with about 125 days or 283 texts per day. This is ridiculous on its face. Now, I'm a 67-year-old judge, so I may not text like some, but this level of contact between a 24-year-old teacher and an 11-year-old student going to an elementary school here in Hudson is unbelievable. And then when you start reading what's in the text, we've seen a lot of the details. I don't want to go through that, but I do want to just list off some of the topics that were discussed over time that I identified. Touching each other, kissing, pushing against each other, touching the victim's chest, feeling heart beating, physical characteristics of each other, dreaming about each other, female sexual arousal, female menstruation, devices used for sexual arousal, oral sex, use of fingers to achieve sexual arousal, licking, body parts, touching victim's stomach, the victim's own sexual arousal, touching legs, expressions of love. I'm so in love with you. I see you in the morning and I get wet. This is crazy, in a sense. And so when I listen to the arguments here, and then I look at the actual text, and I'll get to this in a moment, I'm left with this sense of deliberate purpose and process over time. Because I can see in my review, and I didn't read 35,000 texts. I read a few hundred probably. But what I saw there was the salacious content started with Ms. Bergmann. Now, the victim would respond, perhaps learning, engaging, and all of that as an 11-year-old might. But these very crude, inappropriate, lurid details generally started with Ms. Bergmann. That's disturbing. So I say that all by way of understanding what the gravity of the offenses are here today. Let's talk about protecting the public for a moment. And this is important in two contexts. First of all, because it's an important factor that we have to discuss in any sense, as we look for the best means to protect the public from that kind of thing happening again to this victim or any other victim in our community. It's also important because it's essentially a factor in favor of incarceration and ultimately a prison sentence. If we need to incarcerate someone to protect the public, that is a factor in whether or not that's an appropriate decision. So talking about it is very important. Based upon what I've read in the file, we simply do not understand the source of this behavior from Ms. Bergmann. At least I don't. I don't know why it happened. I'm going to talk in a little bit here when I get to talking about the defendant herself and her response to all this. We'll talk a little bit about that. I don't know why she did this, why she did it for so long, why she continued to bring up new and more salacious details to talk about with an 11-year-old boy. I don't know what level of supervision would be necessary to prevent her from doing this again. We have varying opinions about the need for incarceration, about as varied as they can be. 12 years, 1 year. But I will say this, for purposes of my conclusions here today, I do believe incarceration in the Wisconsin prison system is necessary to protect the public. So I will tell you that I am not inclined to withhold sentence and place you on probation at this time. We'll get to the details. There's more to come. I just want you to understand, I do believe that there is a level of protection of the public that's necessary. And I say that, let me just say one last thing about that for the moment. And I say that because I think there needs to be some in-custody distance between Ms. Bergmann and these events. And I think that will be a positive for the community, and ultimately, frankly, I think it will be for Ms. Bergmann as well, though I know she doesn't agree with me on that. Now, let's say a few more uplifting things from the defendant's point of view. I want to talk about the defendant for a moment, specifically. You don't have a criminal history, okay? And that's to your credit. And I don't want to minimize that, because I think that's important when it comes to a determination of what the ultimate sentence is. You didn't have any trouble on bond. You did what you needed to do. We even, as Mr. Tamburino said, we modified bond. I think we took the GPS off after a period of time, and that was positive as well. I think that you demonstrated that you can be in the community and follow the court's orders. You've been engaging in rehabilitative efforts. That's to your credit too, okay? Whether it's in custody or out of custody, and I think that's a positive. And I've looked at some of the medical records, I've looked at the psychosexual evaluation and what that talks about as well. Now, let's talk for a minute about the defendant's response to these events. We heard some of it here today, and I think there were some positive aspects of that as well. Obviously, she's remorseful about the circumstance. She's offered apologies, and I think that's important. In terms of the PSI, though, I am a little bit concerned, and this is what gives me concern in terms of the need for incarceration and the need for a more advanced approach than perhaps Mr. Tamburino is advocating. When I look at the PSI, first of all, with regard to the text messages, I think it's clear, while this was going on, while you were engaging in this activity, you knew it was wrong, you knew you should stop, and you knew that there were legal consequences up to and including jail that could result. Text messages talk about that. So that whole idea of continuing to engage in this criminal conduct while recognizing what you were doing was criminal conduct, while it was affecting a victim, that doesn't go to your credit. And then, in looking, starting on page 17 of the amended PSI, we look at, and I just want to read some of this. Essentially what happened was the PSI writer read a whole bunch of the text to you, and you sort of responded to, what do you think of that? And the PSI writer says, Ms. Bergmann reported all of the things she and EH said to each other in their text messages did not actually happen. She said they pretended those things did happen, but she was texting the victim on how she wanted her significant other, I'm not going to use the name here, to be with her. The defendant indicated she dissociated when she texted the victim and was thinking of an adult, specifically the fiancé, when she sent the victim messages. Ms. Bergmann stated the messages were things she wanted the fiancé to do to her and how she wanted the fiancé to act toward her. The defendant reported the sexual contact that she and the victim discussed in their messages did not occur. She stated they kissed each other only on the cheek and were creating a fantasy in their messages. Right after reading the text to you, or some portion of the text obviously, the PSI writer says, the defendant indicated she does not remember sending them and felt lost and isolated from her family at the time. She stated she was looking to feel wanted and was not getting that from her fiancé. Ms. Bergmann said she's not sure how this situation with the victim occurred and would never say any of these things she said to him to someone her own age. The defendant reported she felt stupid and like a pushover at the time, but the victim told her it was not a big deal and to keep exchanging messages with him. Now, this is all completely backwards. The adult in the room is telling the PSI writer that, I was kind of a pushover to the 11-year-old. So I kept texting, I kept messaging, I kept talking about inappropriate things. Anyway, I just wanted to express my concern about this sort of devolving into fantasy situation when it comes to deliberate, specific, sexualized texts for months, hundreds of times a day to an 11-year-old boy. It's a fantasy and I was thinking about my fiance, not good enough. The last thing I'll say about that was, when I was reading those texts, honestly, I couldn't tell who the 11-year-old was sometimes. I know that sounds crazy, but both sides of the text messaging seems like an 11-year-old in the behavior that was going on there. The sheer quantity and lurid content of the defendant's text belie any concern for the victim, her position of trust, her school, her community. It was intentional, deliberate, purposeful. What was the end game? And I think Ms. Otten alluded to this. Where were we going with this? I suspect something much more serious. That's not to say we aren't here for very, very serious criminal behavior, but I suspect that it would have gone farther had it not been stopped by the parents. And there likely would have been a physical relationship that would have resulted in much, much greater harm to the victim in this case. What I saw in those texts, and I'll conclude here on this topic, is an exercise of control by a 24-year-old woman who should have known better, and for reasons I don't understand, continues to do this for months on end, despite her consciousness of guilt. Now, we have to talk about the victim, as we should. And, I was struck here today by what Dad had to say, and that was very immediate, very specific. And I was also struck by the letter, but I balanced that with Mom's comments about, jail isn't the answer. And I think that's probably a fair, that somebody may approach this and say, I don't care about jail. And somebody else might look at it, another victim or member of the family might say, it ought to be a whole lot of jail, a whole lot of prison. And I understand that. And I don't find it inconsistent, I just find it's a different point of view. Different people with a different point of view. But this whole process, everything that happened since this began in December of 23, has been devastating to the victim, life-changing to that young boy. And we saw how, you think back on when you were 11 or 12 years old and going to school and how hard it was anyway. And now, what about this? There's stories about this, for heaven's sakes, in London newspapers. Imagine how devastating that would be. That's not to say that people should, that Ms. Bergmann is responsible for that in the specifics of how far this goes. I'm not saying that. I'm just saying that's the world we live in. And the salacious nature of this particular set of crimes brought attention. And that attention creates greater trouble for the victim and the family and our community and the school system. So, I am very disturbed about the impact on the victim. Now, there's an element of sentencing that we haven't talked about here today. You didn't bring up, that I think is very important. I'm going to spend a couple of minutes on it. It's called deterrence. Deterrence is a proper purpose of sentencing, because we have here before us 3 felony crimes from someone in a position of trust in our community here that deserves us considering what is an appropriate sentence to be certain that we send a message from this bench here today that this kind of behavior is not tolerated in our community and in our state. 35,000 texts, 283 a day, a level of emotional control and sexual contact that is offensive. A breach of trust to the student, to the students at that little elementary school, to the faculty at that school, to the parents, to our entire community. It's just hard to imagine the scope of the aftermath in this age of instant media, whether it's press or social media. And what does that do? Parents have to be confident that their teachers are doing the right thing. They have to, because they entrust their kids to the teachers every day. And when these kind of events happen, parents start to wonder. I wonder what else is going on. Conspiracy theories abound. All of that happens. And so sentencing in this case does involve a certain measure of considering what will deter this from happening in the future. Because we as a community, our school district, and the school districts in the state cannot afford to let this kind of thing happen, at least to the degree it's within our power. There's another factor in sentencing that was mentioned only briefly, and that is punishment. Punishment is a legitimate factor that's mentioned in Galleon, and not without, it's an important consideration here too. Because as we look at, and I think Mr. Tamburino, you made very good arguments about the rehabilitative services outside of incarceration, about your client's ability to be in the community, and perhaps the public can be safe. At the same time, we also have to recognize that for certain crimes, certain punishment is appropriate. And this is one of those cases where I think some punishment, as I said, in the state prison system is appropriate. So now let's talk about the prison factors, because we must. And that is confinement necessary to protect the public in this case? And I do believe for a time it will be. And to Ms. Otten's point, probation in this case would unduly depreciate the seriousness of these offenses in a way that I haven't offered. I do think this is a prison case because for all the reasons that I've indicated. Now, I also think that the state's request is extreme in this particular case. I don't offer that as criticism. I just offer that as my opinion based upon hearing everything here today. I think that we've got to balance, as I look at some of those cases that Mr. Tamburino pointed out, the enticement cases and other cases. While we are here today and are extremely frustrated and concerned about these facts and this case and the terrible impact that it's having, I also have to be mindful that there are cases even more extreme. with defendants who have long records of that kind of behavior. And in that light, I think that a more appropriate sentence, and the sentence that I will hand down here today, is I'm going to order that Ms. Bergmann be incarcerated in the Wisconsin State Prison System for 6 years. And that she serve 6 years on extended supervision thereafter. That's on count 3. With regard to counts 6 and 8, I'm going to order 1.5 years of incarceration on each. That's the maximum sentence. And 2 years of extended supervision on each. And I am going to run all of this concurrently. I think essentially the outcome here is 6 years in the state prison, 6 years of extended supervision is an appropriate sentence given everything I've heard here today and I've discussed with you. Now, Ms. Bergmann, you're going to have to calm down for a minute because I have to give you some more. All right. Now, first of all, with regard to lifetime supervision of serious sex offenders, and the first charge for which she's been convicted under for child enticement is eligible for serious sex offender lifetime supervision. The parties have agreed to this, but I still need to make some findings for it to be legal. 1, proper notice was given under 973.125 in the form of a pre-arraignment complaint so that the defendant was on notice that this was being requested by the state. Secondly, I do find and continue to find that this level of supervision is necessary to protect the public. The reason I say that is, frankly, once again, I don't know what made you do what you did. And so therefore, I believe that the public needs the protection. And frankly, the parties have agreed with me on this point. We also have a warning that I need to give you with regard to being convicted of a serious child sexual offense. So, because you are convicted of a serious child sex offense, it will be a crime punishable by a fine of $25,000 and 12.5 years of imprisonment or both if you engage in an occupation or participate in a volunteer position that requires you to work or interact primarily and directly with children under the age of 16. You are advised that the following is a prima facie evidence list of the occupations or volunteer positions that require you to work primarily and directly with children under the age of 16. This is not a comprehensive list. This is just a list they put in the statute as examples. Teaching children, childcare, youth counseling, youth organization, parks or playground recreation, and school bus driving. Do you understand all of that?
Yes.
Also, as part of your sentencing, do you understand that I will be required, I'm requiring that you, to order that you comply with sex offender reporting requirements under Wisconsin Statute 301.45 for the rest of your life. Do you understand that?
Yes.
Now, in addition, we've had prior warnings with regard to possession of firearms. Again, no possession of firearms is allowed. Your civil rights, you can't vote or hold public office until your civil rights are restored. Any other warnings we haven't addressed that I think might be appropriate?
I don't believe so, Your Honor.
All right. Now, what do we have for jail credit?
I believe there are, is it 92? No. I thought there was 87 or 89, Your Honor.
So here's what we normally do if you don't know for sure. I'll give you a week for one of you to send me a letter telling me for sure what you agree the jail credit is. That way you get it right, and then I'll just order the clerk to amend the judgment to reflect the jail credit. Does that work for the state?
That works, Your Honor.
Mr. Tamburino?
Yes, Your Honor.
All right. Let me look at my list. Do we have any restitution requests? I haven't heard anything about restitution.
Not to our knowledge, Your Honor.
All right. So we have to assess costs. We have 3 felonies here, and we'll order minimum costs. $268 of costs per felony. So that's $268 times 3. Plus $250 for the DNA surcharge times 3. I'm just going to order collection through the Department of Corrections on extended supervision. There will be, they may try to collect some of that through your any kind of prison receipts that you have, but I don't have any control over that. That's done by the Department of Corrections.
Your Honor, we do have a large cash.
Oh, we have cash bond. Okay. Let's take a look.
That's correct.
She's in custody now, but... What have we got?
25,000.
25,000? All right. So all that will get paid, and then once that has been paid, the balance of the bond will go back to whoever paid it. Okay? You'll have to have your DNA taken. They'll take care of that in custody. And we need to talk about conditions of extended supervision. That's the one thing we haven't talked about. So, have you had a chance to look at the conditions in the PSI, Mr. Tamburino?
Yes, Your Honor, I believe it's on page
Very end of the...
46.
I found all those conditions to be appropriate and suitable. Basically, there's no contact with the victim and the victim's family. No contact with anyone under the age of 18 without prior agent approval once you're released. Complete a sex offender sexual deviancy evaluation and follow through with any treatment or recommendations. I am going to say that if at the time that that's done, that prior work can substitute for redoing the work, I'm going to leave that to the discretion of the agent to determine whether or not I know you've had a psychosexual evaluation, you've been undergoing some treatment, and so I'm not going to require that it all start over. I'm going to leave that to the agent's discretion. You'll comply with any programming recommended by the Compass Assessment and the Department of Corrections. You can't use the internet and any forms of social media without prior agent approval. You need to comply with the Wisconsin Sex Offender Registry program requirements. And we've already covered court costs. So I think we've done that. You are not eligible for the Challenge Incarceration Program or the Substance Abuse Program, and that will be reflected on the judgment of conviction as well. I do think that I've come to the end of my list, other than appeal rights. Is there anything, Ms. Otten, that you think we haven't addressed?
I believe we have it all covered, Your Honor.
Mr. Tamburino?
Agreed.
You have 20 days to appeal the decision of this court with regard to your sentence. Your attorney will go through a form with you that will describe your rights. You'll be able to make a selection on the form, and that will get turned into the clerk. For now, you are remanded back into the custody of the St. Croix County Sheriff for delivery to the Wisconsin State Prison System in due course to serve the sentence of this court. We are adjourned.